Welcome to Littlejohn Law. My name is Attorney Edward Littlejohn, and I'll be the Chief Strategist and Trial Lawyer on your case. First, let's begin by explaining the process to which we evaluate a claim. When somebody comes into our office, we focus on evaluating their claim in terms of three parts: liability, collectability, and damages. So when we're looking at liability, we're looking at who the responsible party is in terms of the wrongful conduct that had occurred. So let's say, take Tom for example. Tom calls our office and he wants to sue Stephanie for a breach of contract. We have to evaluate the claim to determine whether or not Stephanie violated their contract. The next thing we're going to look at damages. What is Tom out? How is Tom injured by Stephanie's breach of contract? This is important because if we can't prove liability and damages, then we cannot win at the trial. But here at Littlejohn Law, we take this a step further. What we look into is collectability. That is the third, and I think all three are equally important. Now, collectability, what we do is we look at whether or not Stephanie has sufficient assets to cover a lawsuit, okay? So let's say we go to trial and we actually win the case. What then do we get to do? Can we garnish Stephanie's wages? Does she work anywhere that we can garnish her wages? Does she own any assets that we could put a lien on, or any bank accounts that we could levy? If we can't answer that yes, that she has some assets, then it may not be in our client's best interest to proceed through a lawsuit. In any event, we try to resolve a case outside of court before we get into court. That's also a part of our evaluation process. We'll put together a demand package and send it to the opposing party to see if they can comply with our request. Now, in the event that they do, everyone's happy, we get the case resolved out of court, our clients get to move on with their lives. In the event that they don't, then we have to sit down and discuss whether or not we're going to move forward into a lawsuit. Now, lawsuits take several months, and in the worst case scenario, years. Let's say, for example, Tom files his lawsuit against Stephanie for breach of contract for approximately $10,000. Okay? First thing is, under the law, Stephanie gets 28 days to answer. So we're looking at almost a month. She has a month before she has to respond to the lawsuit that Tom filed. Now, even at that point, we're not in court. All we've done is filed legal documents, commonly called pleadings, to set the court, make the court aware of our case. From that point in time, Stephanie gives an answer, and in some situations, she may file a counterclaim against Tom. If she files a counterclaim, then Tom has another 28 days. So now we're looking at 60 days before we're even into court. The next part of the lawsuit is what's called the discovery phase. And this is where the parties exchange documents and exchange evidence, because under the Ohio Rules of Civil Procedures, the advocacy should be a fair proceeding. We want to make sure that both parties are aware of all the evidence that's involved. So this commonly involves depositions, interrogatories, and then also requests for admissions. But again, we're several months out, at least 60 days on a fast track. From there, we take all the evidence that we have, and the defense takes all the evidence that they have, and we file what's called dispositive motions, or motions for summary judgment. And what that means is we stack all the facts and the evidence that we have, and we evaluate it to the law, and we try to convince the court that there is no genuine issue of material fact. And what that means is, if you believe all the facts and evidence as true, we win. This is really important because this can end a case immediately. Now, if you lose on summary judgment, then the case goes on to trial. You have to begin trial preparation, and in many cases, trials are 2 or more days long, just depending on the complexities of the case. Once you have your trial, we go to the next phase, which is either collecting of the judgment or an appeal if necessary. As you can see, this litigation process can take several months, if not years. And trust me, I've seen cases where people have been involved in litigation for years with no favorable results, which is why we focus heavily on resolving the case out of court before we get to a lawsuit, so that we can advocate for our clients and serve what's in their best interest. But we do understand that in the right situation, we must go to court, and we are prepared to do so. I hope you enjoyed this video on the litigation process.